request that you mute your microphones. Ordinarily, we should have been meeting in some fancy place where, in addition to exchanging ideas, we'll chat with each other and network. Unfortunately, these are certainly not ordinary times. The coronavirus has forced us into tight corners. Like most countries in the world, African countries responded quickly to the threats posed by the virus. Many countries, with South Africa in the lead, introduced drastic measures designed to bring the pandemic under control. Coming at a time when there were already increasing signs of a democratic reversal on the continent, many of these measures threatened to undermine the little gains made in the last 3 decades to entrench a culture of constitutionalism, respect for human rights, and respect for the rule of law. There is also an increasing risk that the crisis will aggravate the problems of poverty, inequality, and social conflicts in general. It is becoming clear each day that the struggle to deal with this deadly microbe will be a marathon and not a sprint. How can we deal with this crisis without undoing the limited progress in democratic development? How can we use this crisis to correct some of the errors of the past? How can we use this as an opportunity for innovation and creativity? The threats posed by this pandemic to Africa's faltering steps towards a culture of constitutionalism has not received the attention that it deserves. This seminar, with a focus on assessing the implications of COVID-19 pandemic regulations on human rights and the rule of law in Eastern and Southern Africa, provides us with an opportunity to address some of the issues. As we do so, we should bear in mind that we are not only dealing with this pandemic, but also preparing for the next one. It is a privilege and an honor for me to introduce the panel of 3 eminent and distinguished persons who will be making the formal welcoming and introductory remarks. Let me start with Professor Christoph Heinz. He is the director of the Institute for International and Comparative Law in Africa, University of Pretoria, and a member of the United Nations Human Rights Committee. Let me also add that Professor Heinz is the former United Nations Special Rapporteur on extrajudicial summary or arbitrary executions, a position he occupied from 2010 to 2016. And before then, he was the Dean of the Faculty of Law of the University of Pretoria. He will be followed by Dr. Anne Wolf, the director of the Konrad Adenauer Stiftung Rule of Law Program for Sub-Saharan Africa, based in Nairobi. My guess is that he is the longest serving director and is without doubt one of the leading experts on the rule of law issues in Sub-Saharan Africa. And the introductory remarks will be made by Professor Frans Viljoen, the director of the Center for Human Rights at the University of Pretoria. He is also probably the longest serving director of this center, and Professor Viljoen is the author of the most authoritative book on the African human rights system. So let me, without further ado, invite Professor Christoph Heinz to make his welcoming remarks. Over to you, Professor Heinz.
Thank you. Thank you very much, Charles. And good morning, everyone in different parts of Southern Africa. This is at least one of the advantages that we have from the technology, that we can link with each other from so many different places. For myself, I'm at the cradle of humanity at the moment, not a fancy place as Charles has referred to, but certainly a place worth visiting and a place of reflection as well. So it's a pleasure for me to welcome you on behalf of the Institute for International and Comparative Law in Africa to this online seminar on assessing the impact of COVID-19 regulations on human rights and the rule of law in Eastern and Southern Africa. Let me warmly congratulate my close colleague at the Institute, Professor Charles Fombat, with this excellent initiative. and thank the many speakers who will participate over the next 2 days and everyone else who will join us. We are very grateful to the Konrad Adenauer Stiftung for their support over many years. I think this is the third major conference that they are supporting, and they also support us with the annual seminar that we have in Stellenbosch, and we welcome because it brings people from the region together to work out our own response to this worldwide challenge. It is in the nature of a pandemic that it will call for special exercises of state power. And in some cases, one can even argue that the state has an obligation to do so, obligation to protect health and so forth. But I think it's important to keep in mind that there are two consequences. One is there may be legitimate restrictions on the exercise of rights. Sorry, there's just a helicopter passing over. So two consequences, that there will be legitimate restrictions on the exercise of rights. So it's in the nature of the pandemic that there will be restrictions on rights. But the second one, I think, is the one that we need to be particularly vigilant about, that even against this background of restrictions, there's the potential, the possibility, and the danger of the abuse of these powers of restrictions. And the challenge then is to how ensure that the pandemic is not used as a pretext for extended and overly broad restrictions on rights. From my own perspective, Charles mentioned the Human Rights Committee. We were just working on a general comment on peaceful assembly. And it's clear, yes, in many cases, states have the power, for example, to restrict peaceful assemblies. But at the same time, there's ample evidence that in many states, this power is now abused, in particular, to silence the opposition. And this meeting is an opportunity to reflect on how to make sure that what is on the one hand legitimate state powers is not abused. So in addition to that, very briefly and to conclude, I think it's clear that any emergency have potentially long-term implications. It has implications that measures taken during the emergency may have a life of their own beyond the emergency. In other words, there's the danger that structural damage may be done to the very foundations of the system of rule of law and of human rights. There's the danger that the exception will become the norm, that it will become the new normal. It has been said that one of the important issues during such a pandemic is the issue of social distancing, not only in a way that we know it, but also in the sense of social distancing between new laws and ad hoc regulations that take place to address the pandemic and the basic constitutional and other structure of the country, that there must be a separation between what one wants to remain in the long run and then measures that come in, that there must be social distancing so that once the pandemic is over, and I think that will really be one of the tests, is to make sure that these additional measures are removed and the basic structures continue to play the important role. So from my perspective and from the Institute for International and Comparative Law in Africa, a very welcome, a warm welcome to all of you and best wishes for a productive conference. I thank you.
Thank you, Professor Hens. I can't reiterate the point you made about Dr. Anne Wolf, the support that he's given us over the years in the programs that we've tried to organize. And as you rightly point out, and that's one of the purposes of this seminar, we must avert the danger of the exception becoming the rule. Let me now invite Dr. Anne Wolf to welcome us.
Yeah, dear Professor Heinz, dear Professor Villion, dear Professor Fombert, firstly, it is good to see you. Although it's virtual only, I'm very satisfied that you are all healthy and doing well. Especially looking at South Africa out of the Kenyan perspective, we so-called other Africans feel a bit scared about the incredible numbers of infected people in your beautiful country. We pray for you and we hope it will be getting better soon. But we know also that the numbers in many other African countries are not correct, and there is probably not so much different in cases as it looks on the first view. Secondly, I must admit that I miss our regional conferences and workshops, which CAS rule of law program is usually doing at the time of this year, at this time of the year. February was the last time I flew in an airplane, and since this time I work from the office or from home. To head a regional program in Africa without the chance to travel is, to be quite honest, not really exciting. I hope this will change soon, especially for my successor, Dr. Rothenberger, when she will arrive, hopefully some in this year from Germany, and she will take over the program then from my side. Thirdly, I like to introduce all participants into the work of the CAS rule of law program worldwide. Freedom, justice, and solidarity are the basic principles underlying the work of the Konrad Adenauer Foundation. The Konrad Adenauer Stiftung is a political foundation closely associated with the Christian Democratic Union of Germany. CAS, as we call it, runs 6 rule of law programs worldwide. One is in Bogota, also a country which has Colombia, which has high numbers. The other one is in Bucharest in Romania for South and Eastern Europe. Then we have one project in Beirut for the North African states and the MENA states. And I don't need to tell you anything about the situation in Beirut at now. Then we have an office for China, for Asia, for the region Asia in Singapore. And since November last year, we split this program for Sub-Saharan Africa in kind of Francophone speaking countries in Africa and Anglophone speaking countries in Africa and Luophone countries as well. And this office is in Dakar in Senegal, which is running by my colleague Ingo Badorek, and the office here in Nairobi, which I'm heading. The objective of the rule of law program for Sub-Saharan Africa is to contribute to the development and strengthening of effective legal and judicial systems which conform to the requirements of rule and law and can support the same. In order to achieve its objectives, the program implements a variety of activities in collaboration with various partners like the University of Pretoria on the continent. These include, but are not limited to, convening of conferences, workshops, seminars, and other similar fora, as we see now webinars, that will bring together various stakeholders, study and information visits around the world, as well as research, analysis, and publication of comprehensive reports on the subject of the rule of law. The ultimate aim of such activities is to provide a platform for the exchange of ideas, experiences, successes, and challenges with a view of analyzing them as means of finding solutions to some of the problems in the region. This program does not pretend to have solutions to all challenges on the rule of law in Africa, but it believes that together we can overcome some of these challenges. The success of this program depends entirely on the acceptance and support of all stakeholders in Africa. Fourthly, I like to thank our partner, the Institute for International and Comparative Law in Africa and Center for Human Rights of the University of Pretoria, especially Charles Fombart, for organizing this important and interesting online seminar. As you all know, we live since the beginning of the corona crisis under very abnormal and strange circumstances. Our personal freedom is limited, the right of free assembling is restricted, and many other human rights, for instance, also the right to work, is challenged by decisions of our governments. One of the important questions is, for how long can this go on? How long is it constitutional? And what will happen to the rule of law if some leaders of our countries find themselves very comfortable in this situation? We all know that crises are sometimes, or in many cases, crises are actually the start of autocratic systems or dictatorships. So it's something very important which we want to discuss in the next 2 days. And these are only some questions which will be raised in this online seminar. So don't let me waste more time of our limited time for this webinar, and let me hand over to the microphone to my friend Francis Villjon. Good friend, Francis, the floor is yours. Thank you so much.
Thank you very much, Dr. Wolf, and thank you to the chair, Professor Fombat. I also add my word of welcome to everyone on behalf of the Center for Human Rights, and I happily thank Konrad Adenauer Stiftung, Arne and Peter, his colleague, for support over many, many years. I add my voice to acknowledging and congratulating Professor Fombat for really initiating the thinking around this, bringing this event together, ably assisted by his team, Dr. Abdulruf, and then also Tresor, technically also assisted by Simpiwe on our side. Thank you to you all for your assistance in this regard. I also note with some satisfaction among the presenters, 5 alumni of the center who've done the Masters in Human Rights and Democratization with us. I welcome you in particular, not to say that you are in any way exceptional, but it's just to confirm our link with you and happily seeing you here or seeing you later today. We agreed with Professor Fombat that the papers from these presentations will be published, we hope, after a suitable process of peer review in the African Human Rights Law Journal. I'm very happy to see of the 15 papers that 13 had actually been circulated. That's a very good sign of the way forward for quality presentations and papers. And it is really an honor for us at the journal to have these contributions, because we also celebrate 20 years since the launch of that journal. And I think it's very suitable that we have these quality papers speaking to a very current issue published in the journal in this year of our celebration. So thank you in anticipation for that. Allow me to say a few words of around the conference itself, or the webinar. I think in terms of the spatial scope, I think one of the presenters speak about the spatial aspects of, for example, the right to water. I would like to emphasize its dimension around the national, the sub-regional, the regional, and the global. I see that there are presentations here from East Africa and Southern Africa, 3 from East Africa, Uganda, Kenya, and South Sudan. And then from Southern Africa, we have Malawi, South Africa, a few, Lesotho, and Eswatini. So I think it has a good comprehensive reach of issues in this region from the national level. It's interesting that at the sub-regional level, we also have a paper speaking to the East African community and how the pandemic had an impact at that level. And I think a number of papers take us to the 3rd level, the continental level, looking at comparative experiences and drawing some kind of continental perspective that I think also will add great insights to our thinking around this topic. And then lastly, I think the global kind of is there overarching. I think a number of papers look at the impact of the international human rights dimension and how it impacts and also influences the work at the, at the national and the sub-regional and regional levels. So I think that shows the richness of the scope of the presentations and the scope of the interrogations that we'll engage in. As far as the substance is concerned, I think that I would like to use 2 adages. The one is no right is absolute. And that brings us to the human rights kind of dimension of this, which is, if you like, the Center for Human Rights focus. The other adage will be power corrupts, but absolute power corrupts absolutely. And that's saying that is ascribed to Lord Acton in the 19th century. And that brings us to the rule of law. So I think it's about human rights and the rule of law. As far as limitations of rights are concerned, I think Christoph referred to that already. It begs a number of questions. For example, how does the limitation of the right to life linked to the right to health actually operate in circumstances like these? If in principle the right to life can be limited, can it be limited, especially in a context we have low numbers of infections and deaths? Can the life of the few, the right to life of the few, be somehow limited by the right of the many to livelihood, to an economic survival, if you like, as a society? How do we strike that balance without perhaps falling into the trap of a crude utilitarianism, where the interest of the individual becomes sacrificed for the interest of the public, more broadly speaking. I think we all know that many rights are affected by the pandemic. We have in particular the right to freedom of movement because of all the kind of travel restrictions, right to dignity, right to privacy, especially in the context of surveillance and contact tracing, and certainly also a right to freedom of assembly and association through the prohibition of gathering. So there the question also is for me, how does one balance the various interests concerned? And in particular, I think, how does one, in the end, create a holistic view? And I think that sometimes seems to have been lost, that we focus on one particular interest, one particular rights perspective, without thinking of the human being as having both a right to life and health and dignity and assembly and movement rights all at the same time. And often we see this kind of juxtaposition of various rights, which I think we should also productively interrogate. As far as the abuse potential of power is concerned, Christoph referred to that as well. And I think there we could look at three issues that emerge, and I think some of the papers speak to these. The first for me is the militarization of our response. In South Africa, in many other countries, we've seen the military play a very important role. And that often had led to this culture of excessive use of force. In South Africa, we have the infamous case now of Collins Causa, and that has reverberated around the country. But I think we have Collins Causas in many African countries. And in fact, in South Africa itself, it was not only Collins Causa, but at the time when his death was a cause of great concern, the Independent Investigative Directorate had reported to Parliament that there were at least 11 other deaths in detention. So clearly we should be gravely concerned about this culture of militarization and excessive use of force. The second is, I think, this balance between using the emergency powers under the states of emergency regulations and legal framing of the issue, as opposed to seeing this as in a sense, embedded in the ordinary laws, the limitations kind of regime that ordinarily applies. How do we strike a balance, and how do we ensure governance in that polarity? And the last, I think, is that of transparency. The way that laws are actually communicated in these times is certainly very important, because ultimately, whether it's the human rights perspective, whether it's the rule of law perspective, governments have to take their nationals, their citizens, people in their countries along. The questions of legitimacy, of keeping people as trust, it really is central in this pandemic as well. So I hope that these remarks will be interesting for us to keep in mind, but I do already note that many of these issues have been integrated into the papers that will be presented. So I commend the authors, the presenters. I really look forward to these presenters. And once again, thank you to all. Congratulations, and we all look forward to very interesting and important 2 days of discussion. Thank you.
Thank you very much, Professor Frans Viljoen. I think you've very aptly and accurately captured the scope and the depths of the discussion that we'll be having during the next 2 days. Let me also thank Professor Christoph Hens and Dr. Anne Wolf. I know all three of you are very busy people. We really appreciate you sacrificing some of the time to come and open this seminar for us. This is the end of the first part of this first session. Before I move to the second part of this first session, let me say a few things. First, I want all participants to note that these sessions are recorded and you can always watch it on YouTube at your convenience. Secondly, that the second session will start at 2 p.m. Now let's move to that second part, and I'll start by introducing all the three speakers. The first paper will be presented by Dr. Lukman Abdurrauf, and the title of his paper is Comparative Overview of the Constitutional Framework for Controlling the Exercise of emergency powers in Africa. Dr. Abdurrauf is a senior lecturer in the Department of Public Law, University of Ilorin, Nigeria, and an ISO LOMSO Research Fellow at the Stellenbosch Institute of Advanced Study, Stellenbosch. He was previously a postdoctoral research fellow at the Faculty of Law, University of Pretoria. Dr. Abdurrauf obtained his doctorate from the University of Pretoria in 2016 with a thesis on digital rights and data protection. Dr. Abdurrauf's teaching interests and research interests include digital rights, digital constitutionalism, and constitutional law. The second paper is jointly authored by Dr. Nkatha Kabira and Dr. Robert Kibugi. The title of the paper is Saving the Soul of an African Constitution, Learning from Kenya's Experience with Constitutionalism During COVID-19. Dr. Kabira is a poet, an author, and a senior lecturer at the School of Law, University of Nairobi. She is also an ISO LOMSO Fellow at the Stellenbosch Institute of Advanced Study, a Fellow at the Institute of Advanced Studies, Berlin, and a Fellow at the Institute of Advanced Studies Program on Social Sciences at Princeton University. Dr. Kabira was recently appointed as a Distinguished Africanist Scholar at the Institute of African Development at Cornell University. She completed her doctoral studies at Harvard Law School in 2015. She lectures widely and has taught both in Nairobi and Harvard, and has received numerous awards in recognition of her excellence in teaching. Her co-author, Dr. Robert Kibugi, is a senior lecturer of private law at the University of Nairobi. Now, the third paper will be presented by Mr. Martin van Staden, and the title of his paper is Constitutional Rights and Their Limitations, a Critical Appraisal of the COVID Lockdown in South Africa. Martin is the head of legal policy and research at the Free Market Foundation in South Africa. He is presently pursuing an LLM at the University of Pretoria. In his 2019 book, The Constitution and the Rule of Law, an Introduction, he analyzes the relationship between the rule of law as a meta-legal doctrine and the Constitution of South Africa. Since the South African COVID-19 lockdown began, Martin has written several opinion pieces that have been published widely in the popular media on its injurious consequences for constitutionalism and individual freedom. He has also given radio and television interviews on these issues here in South Africa. Without further ado, I will now invite Dr. Abdurrauf to make his presentation.
Thank you very much, Prof. I hope you can hear me very clearly.
I think I'm getting you clearly. I hope the others are.
Okay. Thank you very much. Greetings from good morning, a very good morning from warm Nigeria. The title of my presentation is a comparative overview of the constitutional framework for controlling the exercise of emergency powers in Africa. Unlike all other presentations, this one is more broad in it's broader in scope, in that the COVID-19 situation or the COVID-19 crisis have brought about a situation wherein academics will have to reflect on the use of emergency powers or state of emergency powers. Even though most African countries did not really invoke their constitutional provision on state of emergency powers, it is actually interesting to revisit this body of laws or this body of provisions in the Constitution to see the nature and the scope of applicability for the purpose of understanding the safeguards that are embedded in them. Now, we all know what emergency powers is all about. The need to act swiftly, or the need to act as a result of certain exigencies that has been brought about by time, or that has been brought about as a result of certain emergencies. The problem with Africa and the use of emergency powers is that they are very highly, or they are highly prone to abuse. We see a situation of Egypt that was on perpetual, or that was on a perpetual state of emergency, that was on a state of emergency for almost 44 years. We've also seen the case of Zambia that was on a state of emergency for 27 years. Now, constitutional draftsmen or constitutional reformers have actually thought this through to see how to curtail emergency powers. You see, before 1990, emergency powers were actually used. It was sort of a mainstay of most autocratic government. But then, post-1990 constitutional reform process have actually thought it wise to instill some checks or to put in place some mechanisms to check against the use of emergency powers. And that is one of the essence of this particular presentation, to see how far they've gone. Have they been able to achieve this set objective? Now, for the purpose of this presentation, I'm going to touch on 4 main issues. First, the international and regional influences that underline the various constitutional frameworks on state of emergency in Africa. Then I'm going to also talk very briefly on the different types or different categories of emergency provided in the Constitution, just like a sort of a broad overview of the nature of emergency powers that are provided in African constitutions. And I'm also going to talk very briefly on how effective this constitutional framework are. Then finally, some reflections side by side, or some reflections based on the COVID-19 situation or the COVID-19 crisis. The first aspect now, international and regional influences on the approaches to state of emergency. We know that state of emergency powers are powers that are very, that involves a high risk, or the exercise of state of emergency powers involves actually a very high risk. And that is for this reason that states or countries are not entirely free to design their emergency powers in the way they are. They have to make recourse to certain guidelines that have fortunately been provided for in international instruments or international frameworks. Now, the first instrument is the International Covenant of Civil and Political Rights in its Article 4 that provides for situations in which a state of emergency, or in which emergency powers can be exercised. It also talks about instances wherein rights can be derogated from and provide a list of non-derogable rights. Fortunately, almost all states in Eastern and Southern Africa, or almost all states in Africa, are signed and have signed this particular international treaty and are bound by its provision. The second most important international instrument, or not necessarily an instrument, the second most important international guideline that helps states in drafting state of emergency powers is the Paris Minimum Standard on Human Rights, or Paris Minimum Standard of Human Rights Norms in a state of emergency, which is commonly referred to as the Paris Minimum Standard of 1984. Although this is a non-binding instrument, it provides a very important guideline for states in designing their state of emergency powers. There are 3 important points to note with regards to the Paris Minimum Standard. The first one is that it strongly recommends a constitutional framework for the exercise of emergency powers. Another very important issue is that it requires that the emergency power should end or should cease automatically as that emergency has been effectively tackled. Then the third important point is that it recommends judicial oversight to ensure due compliance with the rule of law in the exercise of emergency powers. At the regional level, we have the African Charter on Human and People's Rights. The African Charter does not really provide or does not really make any particular provision on emergency powers or on the use of state of emergency powers. But then the African Commission on Human and People's Rights have consistently made it known, or have consistently said that since the Charter is silent on state of emergency powers, states are not at will. States do not have that liberty to invoke, or do not have that reason to make or to use exercise or to exercise state of emergency powers as a result of, say, war or other particular emergencies. There are a lot of controversies with regards to, or there are a lot of opinions on by African scholars, by African human rights scholars, on the lack of provision of state of emergency on the African Charter on Human and People's Rights, which is contained in the paper. Now, with regards to the type of state of emergency in African constitutional practice, basically, there are 2 main models in providing for state of emergency powers. The first one is the constitutional model, and the second one is the legislative model. As you find, or as you see, almost all African countries have actually adopted the constitutional model, in that almost all constitutions in Africa actually make provision for state of emergency powers or exercise of emergency powers in their constitution. There are a lot of reflections, or there are a few reflections on the nature of emergency. One is the dynamic nature of emergencies. As we will see, advances in technology will mean that what may actually constitute an emergency years before now may not actually, or may not necessarily be an emergency now because of advances. We could have technology that could predict an earthquake. We could have technology that could bring in further knowledge on a particular emergency. So what may constitute an emergency years before now may not necessarily be an emergency now. Basically, with regards to the type of state of emergency, there is this issue of determining in advance what may be an emergency. And that is one big problem that African constitutional draftmen have actually grappled with, determining what could constitute an emergency in time to come. And that means that they have to design their constitutional provision in such a way that it is not so wide as to accommodate every form of emergency, or to accommodate or to give room for the executive to declare a state of emergency based on every flimsy reason. And they also have to draft it in such a way that it is not too narrow, so that it doesn't take care of, or it is not too useful in taking care of emergencies as they occur. Now, with regards to the issue of the constitutional framework for state of emergencies, in an analysis of the constitutional framework for state of emergencies in Africa, 4 main issues are usually considered. The first one is, or I considered 4 main issues in my paper. The first one is the general constitutional framework for designing or for declaring a state of emergency. The second one is the nature of the declaration of a state of emergency. The third one is the extent to which human rights, fundamental human rights, are protected in a state of emergency. And the fourth one is the oversight mechanisms put in place in the Constitution. With regards to the first issue, an overview of the constitutional framework. All 54 African countries have adopted, like I've said earlier, or have constitutionally entrenched model regulating state of emergency. However, there are differences in nature, scope, and depth of the application or of the provisions on state of emergencies. In this category, we've categorized our African constitution based on the general constitutional provision for state of emergencies into 3 categories. The first one is the minimalist approach, and that one has to do with countries or the provisions in constitution that only give the executive or the president power to take all measures necessary. An example of this is section 115 of the Burundi constitution. Another approach or another method is another category is the moderate category. And that one is that category basically provides a bit more clarity than the minimalist approach. The most important or the most interesting for constitutionalism is that which provides for a more elaborate approach. And you find in this category the constitution of countries like Gambia and Ghana. This particular provision, or the provisions in the constitutions of this country, provide a fairly elaborate procedure, provide a fairly elaborate process of state of emergencies. And constitutionalists will argue that this is actually better for constitutionalism and protection of rights. The next important issue with regards to the constitutional framework for state of emergency is the nature of declaration of state of emergency. This is a very wide issue which has to do with who declares a state of emergency, under what circumstance are state of emergencies declared, and what mechanisms are put in place, or in what formality or in what model do states actually declare a state of emergencies. Most of these issues have been elaborately tackled in the paper, so I will not dwell much on this particular issue. The next important issue with regards to the nature of state of emergency provisions in African constitutions is the extent to which human rights are protected. In this regard too, African constitutional approach have adopted, you can see 3 main trends, or you can see 3 main categories dealing with the extent to which human rights are protected. There are a group of constitutions that do not mention human rights at all, and that includes, an example in this category is the Somali constitution. The second category in this regard are constitutions that list the human rights that could be curtailed. The third category, which is actually preferable, is a constitution that lists non-derogable rights. And an example in this regard is Section 37 of the South African Constitution. The next important issue is the oversight mechanisms during state of emergency. Generally, there are 2 main oversight mechanisms for the exercise of state of emergency powers. The first one is the legislative oversight, but then this is particularly challenging because of executive dominance of parliament and party caucusing and whip system, which will not make legislative oversight as effective as possible. But then there are various means in which the legislature could check the exercise of emergency powers. There are constitutions that actually provide that before emergency powers could be exercised, there is a need for legislative approval. Some other will provide for ratification of the decision to go into a state of emergency. There are also other checks which legislatures or which are provided in African constitutions that legislatures actually use. An example of that is that which requires that the executive should make reports, monthly reports to the legislature on the use of, on how the state of emergency powers are exercised. The next important oversight mechanism is the judiciary. And in this regard too, we find three approaches. There are some constitutions that provide that intervention or that provides for intervention before or after the declaration of state of emergencies. In some instances, some constitutions actually provide that the judiciary, or you could approach the judiciary to determine the legality or otherwise of the exercise of state of emergency, so activities or acts that are carried out in state of emergency or while a state of emergency is declared. Another approach is that provides for judicial intervention in the role or as in the exercise of the ordinary judicial powers as guardians of the Constitution. In certain instances, you could approach the courts to determine the legality of state of emergency powers. And the third approach is that which provides for a special mechanism or that which puts in place a special process to determine, to settle disputes that arises as a result of the exercise of state of emergency powers. And you could find in this regard, of course, the South African Constitution. Now, some implications of the current trend in Africa. In this regard, the discussion is divided into two. The first one is the constitutional emergency powers and the challenge to rule of law. Over time, we'll find out that state of emergency powers have actually been invoked a couple of times in African countries. But then most of the invocation of state of emergency powers is actually to resolve violent conflict and so on. Violent conflict, restore civil obedience, and so on in African countries. The main issue or the interesting issue for constitutionalism with regards to the exercise of emergency powers generally, as the trend have shown, is that in many circumstances, there may not actually be an emergency before the invocation of emergency powers. Like, for example, you find in Ethiopia, where there was a declaration of state of emergency as a result of the resignation of the prime minister. You find in Egypt, where there was a declaration of state of emergency as a result of certain church bombing and so on. So basically, we found that the exercise of state of emergency powers in many circumstances in African countries over time has shown that there is no any particular consistency. In many circumstances, the executive or presidents merely use this to consolidate power. Now, the legislative emergency power model, the legislative emergency powers is the second category, or trying to look at the implication of the current trend in Africa. And this one is particularly interesting for the COVID-19 crisis. You find out that many African countries did not actually make recourse to their state of emergency powers in the constitution. They merely use legislatures that allow the president to exercise emergency powers. There is a lot of issue, or there are a lot of issues with this particular approach. The first, or one such issue is that there is insufficient check, or there is lack of appropriate, or there's lack of sufficient scrutiny that goes with the exercise of this legislative power, because unlike the constitutional model, legislative powers do not actually provide enough checks to exercise, or in the exercise of state of emergency power. Another important issue is the obsolete, or many African countries actually made recourse to obsolete public health legislation. And in some circumstances, most of them hurriedly try to enact new legislation without following due process of law. Another important issue is the new laws that states have enacted as a recourse or as a result of trying to curtail or control the COVID-19 pandemic, is that it gives powers to unelected executive. You find some of this public health law will give powers to the Minister of Health and so on to exercise broad powers, which are, so to say, arbitrary in a way in that they do not necessarily provide clear checks for the exercise of these powers. Then you also find emergency powers or emergency legislations that have been enacted or which are clearly punitive or which are highly punitive in nature. Like you see the situation in Kenya where the legislature actually rejected the health legislation that was passed to for the purpose of curtailing the effects of the COVID-19 pandemic. Now, in concluding, I have a couple of observations to make. The first one is the absence of rigorous mechanisms to check abuse of powers during the COVID-19 situation. The second one is that constitutions do not actually put in place mechanisms to ensure that the executive use or adopt the least restrictive measures to deal with the emergency. And finally, and most importantly, there is no enough mechanisms in place to ensure that the economic and social hardship that are being faced as a result of the pandemic or that are being faced as a result of the declaration of state of emergency are effectively tackled. Thank you very much. This is what I have to say.
Thank you very much, Dr. Abdul-Rauf. I think from your presentation, there are two things that one can note. First of all, you pointed out that there are two main ways of dealing with emergencies, the constitutional approach or the legislative approach. And secondly, you pointed out in your broad overview of what has been happening in Africa that in the 1990s, reforms were designed to ensure that limits are placed on the misuse of these emergency powers. I think the rest of the presentations will be showing us to what extent these measures to limit abuse succeeded. So I will now invite Dr. Kabira to make her presentation.
Thank you very much, Professor Fombat, and thank you so much for this opportunity to contribute to this very important project. The title of our paper and presentation today is Saving the Soul of an African Constitution: Lessons from Kenya's Experience with the COVID-19 Pandemic. The presentation is divided into, sorry, just a second. The presentation is divided into 4 main parts. Sorry, it looks like it's not changing. Just 1 second. Okay, I think I'll just proceed. The presentation is divided into 4 main parts. In the first part, we will define what we mean by the soul of an African constitution. In the second part, we will examine what happens when the soul of the constitution encounters the COVID-19 pandemic. In the third part, what we will do is use 2 specific examples, one on public order regulations and one on the public health regulations, to illustrate the tensions between the regulations and the constitution. So in this part, we will argue that even though Kenya put in place a transformative constitution that was intended to consolidate the rule of law, democracy, human rights, and governance, the response to the COVID-19 pandemic has raised 2 central issues. The first is that the government's response questions the transformative character of the Constitution. And the second is that it exposes the inherent contradictions that are embodied in the Constitution. In this part, what we will do is explore the idea that the Constitution is a double-edged sword, a site of tension and contradiction on the one hand, and hope and transformation on the other hand. We will conclude the presentation with some lessons on Kenya's experience on constitutionalism. So part one of the presentation, part one, understanding the soul of an African constitution. So 10 years ago, Kenyans celebrated the promulgation of a new constitution. This constitution was aimed at fundamentally restructuring and transforming the governance framework through far-reaching institutional, administrative, legal, and policy reforms. The 2010 Constitution was a negotiated document. The soul of the Constitution was expected to capture the interests and views of all Kenyans, and above all, be responsive to what Kenyans fondly refer to as Wanjiko, the common man and the common woman. The Constitution was expected to represent the aspirations of all Kenyans from all walks of life. At the core of the Constitution is the soul of the Constitution, the overarching principles, the guiding philosophy, the values of the nation, the soul of the African Constitution. The values that are stipulated in Article 10 of our Constitution is what we are calling the soul of the African Constitution. For the purposes of this paper, what we do is limit ourselves to the idea that the soul of the Constitution is what gives it life, what gives it meaning, and that is the rule of law and the respect for human rights. So part two, the soul of the Constitution encounters the COVID-19 pandemic. So on 13th March 2020, the soul of the Constitution encountered the COVID-19 pandemic when the Ministry of Health announced the existence of patient zero, the first person to test positive for COVID-19. And this would turn into months of legal, administrative, social, economic, and public health interventions by the government. The constitutional fabric and governing structure would be tested for its ability or inability to respond to a rapidly evolving situation. Broadly speaking, the strategies can be divided into three main types of strategies. We had the public order measures, the public health measures, and social economic measures, which the government put in place in order to deal with the pandemic. For the purposes of our paper, we limit ourselves to two, and more specifically, the curfew order and the burial procedures. So let's now turn to the curfew order. So on 25th March 2020, the president announced the imposition of a nationwide curfew. The curfew would apply daily between 7 p.m. and 5 a.m. And the rationale of the curfew was that socialization patterns and cultural practices presented opportunities for the spread of the virus. What happened shortly thereafter is that the validity of the curfew was contested in a court case by the Law Society of Kenya, as well as several other civil society organizations. In the case that was brought before the court, two issues were raised. The first was that the curfew order was unconstitutional, and the second was that the use of force by the police in enforcing the curfew was also unconstitutional. So the Law Society of Kenya argued that the government's use of the Public Order Act to declare the curfew did not meet the constitutional standards of restricting fundamental freedoms. The Law Society of Kenya relied on the Constitution to argue that the curfew order violated the rights of persons, the rights to a fair hearing, amongst other rights. The Kenya National Human Rights Commission, as well as the Federation of Kenya Women Lawyers, also invoked the Constitution to argue that human rights and women's human rights had been violated. On the other hand, the Principal Secretary for State Department did not rely on the Constitution to justify the imposition of the Constitution, of the curfew. So what happened is that the court found that the curfew had passed the constitutional test, but also held that the main problem was the manner of implementation of this particular curfew. So the issue, the case raises several issues. The first thing is that when the Constitution encountered the pandemic, the transformative character of the Constitution was questioned. Firstly, as a negotiated document, the Constitution embodies internal tensions and contradictions. And some of these tensions include the tension between individual rights and community rights, the tension between tradition and modernity, the tension between international provisions and the local. And it's also interesting to note that the government of Kenya, in all the presidential and ministerial speeches, makes no reference to the Constitution in all its presidential speeches. Interestingly, it is the civil society and other organizations that are using the Constitution to save the African soul. So while the government has relied predominantly on regulations, executive orders, the civil society actors are relying on the Constitution to push against the presidential directives and the presidential orders. So, for instance, in this case, the Law Society of Kenya is relying on the Constitution to justify its arguments. The Kenya National Human Rights Commission is relying on the Constitution to justify its arguments. So in essence, their role is to save the soul of the African Constitution. The second point is that the government of Kenya did not invoke the state of emergency powers, which, as Dr. Lukman has noted, would automatically trigger parliamentary oversight in restricting civil liberties. Instead, it relied on the public order legislation, which empowers ministers to act without reference to parliament. So thirdly, the role of parliament also in undertaking oversight over the actions of the executive branch came into question. The fourth point is that the questions have also arisen as to whether the government can curtail individual rights and freedoms. And the pandemic has revealed that the expansive Bill of Rights that is contained in the Constitution are based on the classic liberal idea that one who claims to have a right can disregard the wishes or rights of others. So claims for rights are by their very structure trumps against the claims of others. And in the same vein, all Kenyans have a right to freedom of association or a right to freedom of movement, a right to freedom of speech, and a right to socioeconomic rights as embodied in the Constitution. But in the face of the pandemic, the government can curtail your freedoms. So lastly, the Constitution embodies internal contradictions which are embedded in classical liberalism. And what happens is that the tension, for example, between democracy's focus on prioritizing collective rights versus the rights of people to govern themselves is actually in tension. So for instance, if I have a right to property, I can do whatever I want with it, but the police can restrain you when your right infringes on other individuals' rights to property. So in essence, the Constitution is modeling the contradiction, the classic liberal contradiction, which lies in the liberalist demand that the individual be free to pursue his or her self-interest, whereas the pursuit requires restraint of other individuals. So this actually contradicts the idea that African socio-political contexts such as Kenya are premised on the idea that I am because we are, and since we are, therefore I am, as John Beatty classically argues. There is a tension between these individualistic provisions and the interconnectedness between the individual and community rights, as argued by scholars such as Ifeanyi Menkiti. How we implement rights must take into account African social-political realities. And the next case that I will discuss as we head to the end will illustrate this tension even further. So let's look at what happens in the case of burial procedures. Several cases have been brought to court in Kenya, arguing that burials are being conducted contrary to African customary rights with regard to the dignity of the deceased persons. And one such case is the case of Joanne Okoth versus the chief of Ukwala and other government officials. And the facts of this case was that the deceased's body was disposed of like a stray dog, contrary to the deceased's constitutional right to human dignity and his right to be buried in accordance with the Luo customary law, which is one of the communities in Kenya. The petitioners argued that their rights had been violated under the Constitution. They argued that the Luo customary law needed to be taken into account and the rights of the dead needed to be honored and respected. What happened is that the government argued that the peculiar circumstances needed to be weighed against the wider public interest and public safety from the potential spread of COVID-19 and the interest of the individual family of the deceased, whose interest, if granted, would endanger the public. So another government official argued that in the face of COVID-19 pandemic, an individual rights and freedoms can be limited or curtailed for public good or public interest. So the case raises several issues. The first issue is that there's a tension between the traditional rights to bury the dead as protected under the Constitution versus the international guidelines that are outlined in the WHO rules. It also highlights that there's a tension between the individual rights of the deceased person to equality and non-discrimination and to dignity and the rights of public interest and public safety. The tensions inherent in the international versus the local guidelines are based on the assumption that a burial is a private affair, when in fact it is a communal affair that involves celebrations, feasting, dancing, and other activities. In the final part of this presentation, I will reflect on some lessons that we can learn from Kenya's experience with constitutionalism during the pandemic. The first lesson is that it appears that that constitutions, even when considered to be transformative, may not foresee future events that challenge the foundation of the Constitution. But that is why we must constantly interpret constitutions as living documents as they grow in response to new circumstances and new developments. So even though renowned scholars such as Professor Okoth Ogendo, Professor Yashpal Gai, Issa Shivdi, and others have argued that the primary function of the Constitution is to limit governmental authority. During the pandemic, the state was not influenced by the Constitution. It was influenced by the immediate needs of how to deal with the pandemic. And the Constitution came much later, and in some cases hasn't come at all. So in the situation of a pandemic, the government's immediate response is how to deal with the pandemic. The constitutional order comes second. The rights of the individuals are secondary to the needs of the community and the nation at large. And further, individual rights are subsumed under community interests. So you have a lockdown before you think about the individual right to move around. The second lesson is that individual rights issues are being challenged by the African belief on the interdependency of community and individuals. And this is consistent with John Beatty's perspective that the African view of the person can be summed up in the statement, I am because we are, and since we are, therefore I am. So in the African view, it is the community which defines a person as a person, not some isolated static quality of rationality, logic, will, or memory. So in essence, while the community defines a person, a balance is required between the rights and duties of both, that the community and the person towards each other. So this classic tension inherent in rights rhetoric is embedded in the Bill of Rights provisions in the Constitution of Kenya, 2010. The third and final lesson is that the doctrine of supremacy of the Constitution is tested in the face of a pandemic. So throughout the pandemic, the government has relied on executive orders and the enactment of regulations to mitigate the effects of the pandemic. So having recognized the seriousness of COVID-19, the government could have been advised to declare a state of emergency, but it actually did not invoke the constitutional powers in the Constitution. So ultimately, the notion of the constitutional order appears to be broader than merely the text of the Constitution. The government could have constitutionalized their actions. Unlike South Africa, the Kenyan government has not been relying on the Constitution in legitimizing or legalizing their actions. What they have relied on mostly is the executive orders, as I've noted. So in conclusion, 10 years after the promulgation of the Constitution has proved to be a double-edged sword, a site of tension and transformation, a site of tension and contradiction on the one hand, and a site of transformation and hope on the other hand. While the government of Kenya has made major strides forward insofar as consolidating the rule of law, human rights, and governance is concerned, the COVID-19 pandemic reveals that the realization of constitutionalism remains a pipe dream. Thank you. That's the end of my presentation.
Thank you very much, Dr. Kabira, and I'll also thank your co-author, Dr. Kibugi. I think you've highlighted a very important issue. Everybody regards the Kenyan Constitution as very progressive and transformative, but the COVID-19 has posed serious questions as to how such a transformative constitution has been challenged by this pandemic. We'll now go to Mr. Martin van Staden, who will also be looking at the situation in South Africa under a similarly transformative constitution. So, Mr. Martin van Staden, over to you.
Thank you very much for this opportunity to present my paper in such august company. My full paper takes a value-based approach to the constitutional rights regime in South Africa and considers how South Africa's courts have applied it to the COVID-19 lockdown regulations over the last few months. In this webinar, I will provide only a brief overview of the most notable aspects of the paper. Scholars tend to agree that the meta-purpose of constitutionalism and the related notion of the rule of law is to control and limit the scope and exercise of state power. And I don't think at any time in recent history has this been more relevant than today with the global COVID-19 pandemic and the accompanying lockdowns. South Africa's lockdown specifically has been named as one of the world's longest and most severe. And this, of course, no doubt raises an important question of constitutionality and of justifiability. So the Constitution of South Africa, as you noted, Professor Konrad, is venerated around the world for its progressive Bill of Rights. Indeed, it is trite that South Africans have a very generous web of rights recognized by the highest law. So instead of considering each lockdown regulation against the right, the approach adopted was instead to measure the superior court's response against those provisions of the Constitution that control and regulate the limitation of and derogation from rights. These provisions are sections 1, 36, and 37. Sections 1A and C entrench the advancement of human rights and freedoms and the supremacy of the rule of law as dominant constitutional values in South Africa. Each of these notions, that is freedom and the rule of law, have a content that is not spelled out in the Constitution. But briefly, freedom relates to autonomy, the ability to decide for oneself, and is intimately linked to the associated constitutional value of human dignity. The rule of law, no less controversially, in large part controls for legal certainty, predictability, and accessibility. But more directly relevant to the pandemic are sections 36 and 37. In summary, a right may only be limited if it is done in terms of section 36 of the Constitution, and then the limitation must be reasonable and justifiable in an open and democratic society that is based on freedom, dignity, and equality. The section 36 test includes a proportionality or less restrictive means criterion, meaning that if less restrictive means were available to government to attain its objective, that would militate against the justifiability of the limitation. But allow me to emphasize, and the Constitution I think is very clear on this point, that no right may be limited unless it is justified in terms of this provision, period. On the other hand, Section 37 provides for states of emergency. These may only be declared if the life of South Africa is under threat and there has been a breakdown in public order. After such a declaration, rights may be derogated from or suspended to a certain extent or entirely, if that derogation is strictly necessary to control the emergency. The paper considers 4 High Court cases: Khoza versus Minister of Defense and Military Veterans, De Beer versus Minister of Cooperative Governance and Traditional Affairs, SA versus the same minister, and Fair Trade Independent Tobacco Association, or FITA, versus President of the Republic of South Africa. There have been other cases, and most of these cases are in various stages of appeal and review. But they were chosen because the judgments contained remarks on rights limitations during situations like COVID-19 that spoke to general legal principles. The conclusion reached was that Khoza and De Beer came down, and I think quite strongly, on the side of rights protection against executive power. And this is what the courts are traditionally regarded as guardians of the Constitution and defenders of rights. But SA and FITA, on the other hand, came down again quite strongly on the side of executive power against rights protection. A critical analysis of the latter judgments followed in the paper, although I did have some criticism of De Beer as well. Section 36 of the Constitution, it is submitted, was all but ignored in SA and FITA. In fact, it is argued that not only was it substantively ignored, but right protections were actively undermined. Allow me to summarize, but remember that Section 37's provisions did not arise because no state of emergency has been declared in South Africa, as the previous speaker has noted. And every limitation of a right must be justified according to Section 36. In SA, the court went out of its way to point out to the applicants who challenged the regulations that they should have made use of Section 36 rather than comparing the regulations with one another. Correctly, the court was correct. But the court then proceeded to test only for rationality, despite expressly have pointed out, and thus put it before the court itself, that Section 36 would have been the more appropriate and more legally and constitutionally correct course of action. So no Section 36 test was conducted, and the court concluded that the impugned regulations were rational. The court, however, went further and argued that the relevant provisions of the Disaster Management Act, under which the lockdown in South Africa is being prosecuted, must be construed generously rather than strictly or narrowly. In FITA, the applicant argued against the regulations based on rationality again, but the applicant did subsume a Section 36 argument into their rationality argument by putting it to the court that there were less restrictive means available to government rather than the outright prohibition of tobacco sales, of which I think South Africa is one of only 2 countries in the world which have prohibited tobacco sales as part of its lockdown. The court rejected this argument because the less restrictive means test is not part of a rationality analysis. In other words, Section 36 was put to the court by the applicants, albeit very incompetently, but the court did not undertake a Section 36 analysis. Thus, the court was satisfied again that the regulations were rational. But like in SA, here the court also went further and submitted that the word necessary in Section 27 of the Disaster Management Act meant reasonable necessity, but not strict necessity. Section 27 lists the allowable reasons for which regulations could be made during a disaster in South Africa. In both cases, in other words, the court allowed evident and undisputed limitations on constitutional rights to stand without undertaking the constitutionally required Section 36 analysis. The argument will be that Section 36 was not put to the court expressly, but instead rationality challenges were launched. Now, I do not think this is accurate. Section 36 was recognized by the court in SA as the proper legal argument, but then ignored. The Constitutional Court has even observed that a court is obliged mero motu to raise a point of law that is evident from the papers, even if the parties themselves are proceeding incorrectly. And Section 36 was put to the court in FITA, even though that was done quite incompetently and inappropriately by merging it into a rationality argument. This was an oversight of immense proportions, but the most regrettable aspect was the court's conception of how to construe the Disaster Management Act. In SA, the court effectively disregarded the specific words of Section 27 of the Act because it found a general provision elsewhere in the Act to override it. This approach not only contrasted with the rule that all the words and provisions of a statute must be assumed to be operative, but it also abandoned the lex specialis rule that specific norms must be preferred over general norms. In FITA, the court departed from Constitutional Court precedent on this very aspect of the Disaster Management Act itself, where the highest court held that if any disaster management regulation may adversely affect rights, the Act's provision must be construed narrowly or strictly. But not only did the court in FITA depart from precedent, it also effectively rendered the constitutional protections for rights redundant. Indeed, one wonders what is the point of sections 36 and 37 of the Constitution with their specific requirements and checklists for the limitation of rights if mere reasonable necessity could justify an infringement of rights. More generally, South Africa's COVID-19 lockdown has also undermined the rule of law imperatives of accessibility and predictability. The court even noted in the second De Beer case that the regulations were amended prior to the delivery of the application for leave to appeal, again before the hearing, and again since the hearing. Ordinary South Africans surely cannot keep up and depend entirely 100% on the press and the media's understanding of the regulations. That is a clear violation of the rule of law requirement that people must know the law as it applies to them and must be able to understand it, clearly in my view. In FITA, the court, it is submitted, also undermined the rule of law by adopting a form over substance approach rather than what I and former Chief Justice P.S. Langa think are a constitutionally required substance over form approach. This it did by accepting the minister's argument that the goal of the tobacco prohibition regulation was to override the reality of the regulation. The goal of the regulation was to spare healthcare facilities from smoking-related conditions in favor of COVID-19 patients, whereas in reality, it seems the regulation might not have led to a reduction in smoking, which I think the minister recently has even admitted, and perhaps even led to an increase in smoking more harmful black market cigarettes, thus leading to even more strain on healthcare facilities. So the court accepted the arguable reality of the case was disregarded by the court in favor of mere good intentions by government. In closing, I wish to note that these critiques of these high court judgments are meant in good faith and constructive criticism. The courts get it wrong just as often as they get it right. And the legal community, particularly scholars and human rights lawyers, have an obligation to assist the courts to rectify their own mistakes. And this is fundamentally why appeal and review exist, and why the highest court in the land is able to reverse its own decisions when it is palpably wrong. The constitution, any constitution, is not self-executing. It depends on a vigilant citizenry, again, particularly the legal community, to ensure that government abides by its provisions and to then fight those battles in court. The COVID-19 lockdown in South Africa, again, it is submitted, went beyond what the constitution allows. And the constitution did foresee a situation like COVID-19 by having provisions for the limitation and the derogation of rights in sections 36 and 37. But the courts have not fully appreciated this. They have in the early cases, but it seems now that the courts are adopting executive mindedness. So constitutionalism and the rule of law depend on us articulating the problems of government's approach clearly, so as to ensure that if this ever happens again, South Africa's hard-won constitutional dispensation is respected. As you know, we have a very interesting history of states of emergency in South Africa, and we would rather not repeat that history and rather go into the future with a more rights-centric approach. I know this paper focused specifically on South Africa, but I do think it quite aptly amounts to a general cautionary tale about excessive judicial deference to government during a public crisis. In this respect, I hope the paper proves useful to my colleagues throughout Africa and around the world. Thank you very much for this opportunity.
Thank you very much, Mr. Van Staden. I totally agree with you that the rule of law and constitutionalism depends on an active citizenry. We've now listened to 3 very rich and thought-provoking papers. They've raised very many interesting and pertinent issues. And I think we now have the opportunity to open up for comments, for questions, and for contributions. So please feel free. I know there is at least one question in the chat room. I'll read that soon, but feel free if you have any questions, comments, suggestions. The floor is open for that.
I can see that Mr. Tony Clinton has raised the hand.
Okay, please, we give the floor to him.
Thank you, organizers. My name is Dr. Tony Clinton Jaja. I am a lecturer at the National Institute for Legislative Studies in Nigeria, Abuja. I specialize in legislative drafting, where I obtained a master's and PhD in legislative drafting from the University of London. My view on this whole thing is emphasis has to be placed on the drafters of constitution, and they have a major role to play, not just the constitution, those who draft the regulations for restriction of citizens' rights during the COVID pandemic. In Nigeria, we had an example of the presidential regulation on restriction of movements during COVID. One of my law students wrote an article on it. It was a joke. It was prose converted into regulations. the root cause of the problem is the idea that any lawyer can draft legislation or the constitution is a faulty foundation. The legislative drafting is a specialism, and much attention has not been given to grooming lawyers who specialize in drafting legislation for the country or the constitution. I give you an example. The Section 3 of the Petroleum Act of Nigeria, it gives unlimited power to the Minister of Petroleum to revoke or to grant licenses without creating a criteria for which the revocation or grant of these licenses should be done. And there is no procedure for appeal. I conducted an empirical study, and I found that over 500 lawsuits have emerged because of this poor drafting of Section 3 of the Nigerian Constitution. So my contribution is we need to, as Africans, pay more attention to legislative drafting. There are only in Africa, only University of Pretoria, I think, has a postgraduate diploma program in legislative drafting. Nigeria has an Institute of Advanced Legal Studies where they do legislative drafting. Apart from that, most African countries send people to the University of London, because once you deal with, there are techniques of drafting, especially when you're drafting, conferring power. You don't confer absolute discretion. There are techniques mechanisms for checking powers when you donate, especially emergency powers. Once we learn these techniques, the drafters have an obligation, even if the executive is not aware that, look, my powers are unlimited. The drafters have the responsibility. It's a professional ethic to warn the executive that your power to impose restrictions during emergency is not absolute. There are conditions for exercise of that power. Once we pay more attention to this, I believe it's addressing the root cause and not the cosmetic solution to it. Thank you.
Let me just come in. Please, let's keep our questions short so that as many people as possible can contribute. Thank you. Is there any other question? If not, let me read some data in the chat room. One question, I think, to Dr. Abdullah. It says, given your analysis of the oversight mechanisms and the trend of managing the pandemic outside of state of emergencies, do you think it might be desirable for countries to have rather use states of emergencies than disasters or other public health legislation? And in fact, I was going to ask, given that I think both of you have pointed out that countries prefer to use ordinary legislation rather than invoke constitutional emergency legislation, can we blame this on the manner in which the constitutional emergency legislation were crafted? I think is the question that I would like all three of you to answer. And how can we prevent this going forward? There is also a question here to Mr. Van Staden, and it says, I am curious about the role of evidence and knowledge gaps related to the pandemic in decision-making. It seems to me that the lack of certainty about the efficacy of different measures in preventing COVID-19 also plays a role in how the courts evaluate their validity. What are your thoughts? And also, what is the role of a Section 36 analysis if the regulations fail a rationality test as per the BIA? Let me see if there are any further questions. Okay, are there no other questions? Any persons who raised their hands? Mr. Trezor.
There is no one who raised their hands.
Okay.
There was another question to...
Yes, there was another question to Dr. Abdurrauf. And I think I'm looking for it now. Yeah, it says, in regard to the judiciary, would you have examples of how transformative constitutionalism has been used, especially in Nigeria and Somalia, that you mentioned, so as to ensure the rule of law during the pandemic? So I think let me give an opportunity to the presenters to respond to these questions. So I will start with the last presenter, that is Mr. Van Standen. And then the second presenter, and end up with Dr. Abdurrauf in that reverse order. So over to you.
Thank you very much. So I think the first question that you pose is about how is there a problem of how emergency legislation is written? And I think absolutely. In South Africa, our emergency legislation, the State of Emergency Act, has not been invoked. Instead, we've worked under the Disaster Management Act. And I think that it was drafted quite generously. I think the point that the Constitution could not foresee COVID, I think the Constitution did, but maybe the Disaster Management Act did not, in how generously it was drafted. But the problem for me lies more in how the courts interpret and construe these pieces of legislation. As you'll note in my paper, I emphasized the problem of how the courts construed the Disaster Management Act by ignoring certain provisions, Section 27 specifically, in favor of general provisions, so as to enable government to more generously invade rights rather than construing those provisions narrowly, which I think is when you're in a constitutional rights dispensation like South Africa and like many African countries, they must be construed narrowly. So I agree with that. Just a quick comment on Dr. Jaja's point about legislative drafting. I agree completely. Most of my day job is about commenting on how the South African government drafts legislation. There's much to be desired, and our legislative drafters in South Africa are not used as much as they should be. Instead, departments use, I think, general lawyers to draft their legislation, and that's a problem. So I agree completely with you, and I think we should get in touch and talk about how we can solve this problem. Then Safura Karim's point about knowledge gaps. I think, yeah, in the beginning of the lockdown, I think, quite generous in how I interpreted the government's response. It was something new. And for the first few days, there was a lot of goodwill from the public towards government, because we were still finding our feet in the pandemic, and that's understandable. But increasingly, as time went by, the public, and of course, I'm glad to say myself and the legal community have grown impatient, because the constitutional deficiencies in the government's approach have now been laid bare. It's now clear where the constitutional deficiencies are, in my view, and the government is still not bringing itself in line with the Constitution, despite this now having been pointed out. Extingent circumstances keep being cited as the reason for the heavy-handedness, and I don't think that's correct. If the Constitution says you need to act in a certain way, then come hell or high water, the government needs to act that way, no exceptions. And then your final question on the role of Section 36 analysis if the regulations fail a rationality test. Judge Davis, in that case, in the BIR, pointed out that if any regulation or conduct of government fails a rationality test, then it automatically must fail a Section 36 test. So if the rationality test fails, then Section 36 does not arise. But Section 36, I argue, must always arise when there is a limitation on rights. And our courts have been way too conservative in this regard by clinging on to this idea that unless it is put explicitly before the court, it will be ignored. That's a problem. We are in a public crisis situation. Things are moving very fast, and I don't think the public, especially the poor, can wait endlessly for some advocate to at some point put Section 36 to the courts. The courts need to take a little bit of initiative. I hope that answers most of the questions. Thank you very much.
Thank you very much. Let me now invite Dr. Kabira.
Thank you very much, Professor Konrad, for giving me the opportunity to respond to those questions. I think while I agree that there could be some drafting issues, I think at the very heart of it, it's not really a drafting problem, because if I remember correctly, even during the making of the Constitution of Kenya 2010, during the review process, the state of emergency provisions were very much contested. But what happens is that when it is written in the Constitution, the tension between those who argued that Parliament should not have a role in how the provision, in how the emergency is enacted, versus the people who argued that the executive should have absolute powers in times of emergency, there was a tension between just how much power should the executive have versus the legislature. So the Constitution actually reflects that contradiction. It actually reflects that tension between whether or not there should be parliamentary oversight and whether or not there should be absolute executive decree. So in some sense, I do agree that drafting is an important part of the process, but it's also about what you draft, how you draft, and why you draft what you are drafting. Because ultimately, if you draft that everybody has the right to life, and you draft that everybody's right to life can be limited, you're essentially constitutionalizing a tension that exists in classical liberal democracies. So ultimately, what will happen is exactly what the South African case has shown us, that one person's rights trumps someone else's rights. So your rights stop where someone else's rights begin. So I do think that ultimately the question is broader than the drafting. It goes to the very essence, the very philosophy, the very foundation through which we actually make legal arguments and legal argumentation. Yeah, I think I'll stop there.
Okay, thank you very much. And I'm inclined to agree with you that the problem is basically not just with the drafting, but rather what is being drafted. And what is being drafted depends on what the draftman is instructed to put into the Constitution or into a piece of legislation. So he cannot take any initiatives outside the instructions that is being given. So shoddy draftsmanship is one thing, but the lack of content in what is drafted is another. Okay, Dr. Abdurraf, you have the microphone.
Okay, thank you very much for the very interesting questions. With regards to the first question, I believe that the problem is not actually with the legislation, which actually bestows emergency powers on the state government, on the executive to take care of emergency situations. My own belief is that it is actually more of a problem of the Constitution. As a student of constitutional law, I believe that the Constitution should be elaborate enough to be able to accommodate most of the circumstances. It should be wide enough to be able to accommodate most of the emergency situation. So in this regard, for me, I will rather that states opted for the constitution to deal with emergency situation because of, as I mentioned, and as other speakers have mentioned, because of the checks, because of the elaborate checks that are available in the constitution to deal with emergency powers. As we've said, those checks that, or those checks in the exercise of emergency powers are not that explicit or are not so much available in ordinary legislation. So as a student of constitutional law, I believe that the constitution should actually be a better recourse in this regard. Then the question on transformative constitutionalism and its ability to be able to infuse a rule of law in the emergency situation. Usually transformative constitutionalism, or the concept of transformative constitutionalism, is usually discussed with regards to the South African and the Kenyan constitution. With regards to Nigeria and Somalia, I may not be able to readily give examples of how it should be done. But basically, like I said in the course of my presentation, a constitutional provision that is elaborate enough will be able to substantially check or will be able to substantially check abuse of powers in the exercise of emergency powers, even if, or even in circumstances where those emergency powers have been bestowed by ordinary legislation. So that's basically all what we're trying to say. The constitution should be enough, or the constitution should provide that platform. The checks that are ordinarily applicable based on the provisions of the constitution should also be applicable in the case of ordinary legislation. I think these are the response I have to the questions posed.
Yeah, thanks, Dr. Abdurrahman. I think there's still a more fundamental and serious issue based on your presentations. Why did the government avoid relying on the constitution, the provisions provided for in the constitution, and instead relied on public order legislation? The question there is, could civil society have done more to bring pressure on to bear on government to rely on the constitution, which contains checks and balances on how the government will use those powers? And I'm particularly interested to asking Mr. Van Staden, the situation in South Africa. Do you think civil society could have done better to bring pressure to bear on government to act within the confines of the constitution rather than that ordinary piece of legislation?
Yes, no, I think absolutely. One of my criticism in my original paper, it was too long, so I had to reduce it, was that civil society in South Africa, and I think this is fair enough. I think we were all quite caught off guard by the COVID-19 thing, and government swift action was widely praised, and to an extent that's understandable. But in that praise, during those initial 2 months, there were actually none. I don't think any major court cases launched against government. Obviously, no protests because of the regulations themselves. And civil society has only very, very recently started speaking out and taking a more radical approach against government. Because what you say is totally correct. The mere fact that the government in any way disregarded the constitution and tried to act in terms of ordinary legislation, in my view, very much in conflict with the constitution. I mean, to lawyers, that's like an error. That's like an error on a computer. That cannot happen because the constitution is what established the government. The constitution is the very skeleton of government. So it cannot act outside of that. And the fundamental point is that no constitution stands on its own legs. It must be propped up by the people with the assistance of the courts, but particularly by the people. And South Africans have been, unfortunately, a bit slow to start vindicating their rights. But I'm heartened that recently there has been a lot more talk, a lot more movement in this regard, and I hope that continues.
Thank you very much. We still have some more time for discussion, comments.
Professor Fombat, can I speak to that?
Please do.
So your question is why is it that the government seemed to have avoided the constitution or invoking the state of emergency powers under the constitution? But I wonder whether it was something that was intentional, or whether it's the pandemic actually reveals that many of the decisions that the government made and continues to make are taking place outside the constitutional order, or that they're taking place in political processes, and law is coming secondary. I took part in drafting some laws, and everybody, other practitioners such as medics and health workers, they kept saying that there's no place for law in this pandemic. We have to do what we need to do in order to make the most expedient decisions. So the place of the constitution during the pandemic is something that is really questioning the doctrine of supremacy of the constitution. It's questioning really the place of the constitutional order. So I don't know what everybody else thinks about that. Yeah.
Okay, let's listen to the others. But one could argue here that the problem was to avoid the active involvement of parliament, calling government to order, regularly monitoring what they were doing, not necessarily legislation, but actually monitoring them and calling them to order. Is that somebody commenting or what?
I think it was an error.
Okay. Yeah. Are there any further comments, ideas, suggestions, questions?
We have 2 hands raised by Petronil Kruder.
Okay, let's start with him then, and then we'll take the next hand.
The next one is Joe.
Hi, thank you so much. Yes, I was also initially the person who posed the question about, whether or not it's better to use state of emergencies. And, I wonder if the area that we need to focus on is either challenging the initial declaration of a state of emergency, if that might be a good access point. And then the second thing is challenging the actual content of state of emergency legislation, where they provide for less oversight.
Let me just interrupt you for a moment. Please, if you are not speaking, mute your microphone. Mute your microphone. Thank you. Please carry on.
Yes, so I was saying either challenging the declaration of a state of emergency, or challenging emergency legislation which provides for less oversight than local state of emergency laws would, might be a good area of access. I don't know if anyone can hear me now, but I'm going to leave it there. Thanks.
Okay, thank you very much. Let's listen to the other person.
Joseph?
Yes. Sorry, I was waiting for that moment. Yeah, I think there's a question around the role of civil society that Prof. Charles Konrad asked in a state of emergency, and I think the response from South African colleague there is in place. Although when you look to other contexts such as South Sudan, you find that the engagement by civil society organizations creates a confusion in the state of strengthening rule of law and pushing government to be transparent in their decision-making processes. And I think it is a context-specific case, because you have a situation in which you have huge presence of very powerful international organizations. And so they have created, aside from the government processes of managing COVID-19, a very powerful lobby group that challenges every decision that the government makes. So I think whilst we agree that the civil society can influence the adherence by government to rule of law during emergencies, at times they are counterproductive because they like to influence decisions, and there's not always harmonization in effectively managing the COVID-19 pandemic, as we have seen in places like South Sudan. But perhaps that is a very context-specific example. In terms of expertise, we see that they come with a lot of resources and expertise. When we look to agencies like WHO and other INGOs, and I think that then helps the government to effectively manage the response to emergencies. But that comes with a cost, the cost I just mentioned of the confusion as to what direction the government should take. Thank you.
Thank you very much indeed. Any further questions, comments?
Yes, please, Prof. May I? Is Kamga?
Please go ahead.
Thank you. Good morning, colleagues, and to all presenters. Thank you for the good presentations. I would like to react to the last speaker, Joseph. I just perhaps don't understand how we can be concerned if we have watchdogs like civil society watching over what the government is doing. In the context of South Sudan, we also know that these powerful organizations coming from outside the country and other places are interested sometimes. They don't just do this for the sake of doing things. But if we think we need civil society organizations that should have a voice, that should be watching exactly what is happening, that should be able to ask questions. Because if we think the civil society becomes confusing, actually using that, we might end up shutting down civil societies that have an important role to play in this time of COVID-19. Like in South Africa, we can see them going to court. We can, even if, as per Martin's presentations, there are challenges, the government is concerned, the government pays attention, and we want a government that pays attention to civil society. If we think civil society becomes confusing, we can provide a huge bridge to give ultimate power to the government, which becomes dangerous for our freedoms. Thank you. That's just my comment to that view. Thank you.
Thank you very much, Professor Kamga. Do we have any further interventions? If not, I think we've more or less come to the end of this first session. Let me, as chair, thank all the presenters. Let me also thank all of you who were there as participants and for your contributions to the discussion. We will now take a 2-hour break. Let us kindly resume at 2 o'clock, but I think everybody should get in by 10 minutes to 2 so that we can start at 2 o'clock promptly. There is a slight adjustment to the program. Mr. Joseph Gang Akesh, who was supposed to be the 5th presenter this afternoon, will be making his presentation first tomorrow morning. So we will only have 4 presentations this afternoon, and Dr. Anne Wolf, the director of Konrad Adenauer Stiftung, will be moderating. So once again, for my part, thank you all very much, and see you shortly. Bye.